Okay, so first things first, the Immigration Act 2016. This is an extension of the Immigration Act 2014, as I've already said. And this is just detailing to you what we have to do to comply. So, offences for landlords and agents. So as a landlord, if you rent a property to a disqualified person, somebody that doesn't have the right to reside in the UK, you are committing an offence. Now remember, for those that have heard this before, it's not just the tenants that have to comply with the Immigration Act, it's all occupiers. So anybody that's living within the property has to have their immigration status checked. So if you move in a gentleman and he then moves in his wife, you must check their right to rent residency. We must see evidence of their ID and that they have the right to reside. Not informing the Home Office of a disqualified person, both you as landlords and us as agents will be committing an offence if we don't notify the Home Office of a disqualified person. And for an agent, failing to notify a landlord when we know that we're renting to a disqualified person or an illegal person is something that, if we carried out as a letting agent, would be our offence. We would be the guilty party. So in 2016, they changed the penalty for this, and they actually made it now a criminal offence, so that actually we can now face 5 years imprisonment, which is quite scary really, because how hard is it to control who's living in your property? We all know that people make applications, and we all know that people sometimes tell lies on their applications by way of, oh yes, I'm going to be renting that property on my own. They've not told you about their wife because the wife's got a county court judgment, or she's not working, or they might want to just be getting the single person discount on the council tax. But this does happen quite often, which is why with the Immigration Act, for the landlords out there that manage properties themselves, please make sure that you're regularly inspecting so that you are aware of who is residing in the property. Because I certainly don't want to go to prison for 5 years for this offence, and I'm sure you don't too. The fine now is also unlimited, whereby previously it was £3,000 per illegal occupant, but now that fine is unlimited. So with the Immigration Act 2016, they had to make some changes to allow us to enforce this. So, eviction of unlawful overstayers. You could have two scenarios. You could have a property where all of the occupiers or all of the tenants are illegal. They don't have the right to reside. But you could also have a tenancy where you've only got one or two occupiers or tenants that don't have the right to reside. In both cases, you are able and you must evict the tenants that do not have the right to reside, or the occupiers that do not have the right to reside. You have to evict them. But how do you do that? So when we've got unlawful occupants where they are all illegally living within the property, what happens is the Home Office will serve a notice to say these tenants are deemed as illegal and they must vacate within 28 days. Now, Sally talked earlier about the Protection from Eviction Act 1977. This is the first time since that date that in the private rented sector we have been able to evict tenants without going to court. For those of you that have experienced ever evicting a tenant, I know you guys have recently and it's been interesting for you, it's quite a lengthy process, and it's not possible without going to court and getting a possession order and then following on with bailiffs and so forth. But for the first time ever, we can now do, for the first time since 1977, we can now do that. So you can imagine the likes of shelter and these people that are all caring for the tenants and not the landlords were quite concerned about this. But it is the only notice that we can serve, and they must leave within 28 days. If the tenancy is a mixed tenancy where you've got some illegal immigrants, but the others are, you know, perfectly reasonable and able to live there and have the right to reside, again, the notice will be served by the Home Office, but what you're not able to do is take back full possession of the property. You have to allow the tenants that have the right to reside to remain in that tenancy and for the tenancy to continue for the fixed term period. So the way of doing that is they've added a new mandatory ground to the Section 8 notice, which is ground 7B. It's a mandatory ground, and I believe it will give the same required 28 days notice to the illegal overstayers to vacate the property. And the ones that are there correctly can continue with the tenancy thereafter. So unfortunately, as landlords, we wouldn't be able to terminate the tenancy. We would only be able to evict the tenants that were staying illegally. So all in all, it hasn't really caused too many challenges, but it is most definitely something to be aware of and interesting over the next few years how this will pan out, and when case law and things like that start to happen, we'll know more.